Perfect. So without further ado, I will turn it over to Stephen.
Thank you very much, Lauren. Hopefully everybody can hear me all right and see me. I'm sorry I'm not able to join you in person, but maybe the next go around of the roundtable program we will. I also want to thank CAMCO for the opportunity to present on this extremely important topic dealing with fiduciary duty. Also pleased to see so many familiar names, including a host of board members and lawyers as well. So again, welcome. And it's my sincere pleasure to present on this topic. It's one of my favorites. I call it the infamous F word for fiduciary duty. There is nothing, in my estimation, which is more important than for all of you to grapple with and fully digest and understand this concept of fiduciary duty. It drives the decision-making process for all community association boards. And if you'd like, you should download a copy of Section 3303 or 5303, depending upon UCA or UPCA, Uniform Condominium Act, or Uniform Plan Community Act section, and keep it by your side. I'm serious, because if you can memorize those sections and understand fully what those concepts mean, you'll be in great shape in running the affairs of the association as a fiduciary for your community association. It also means, as we'll get to in a few moments, that if you follow those standards that are well laid out and articulated within the prevailing statutes, there shall be, quote, no liability for a board member. And in my book, and I suspect yours, that's a real good thing. All right, Lauren mentioned about questions. I'd be happy to take questions during the course of the program. I enjoy more of an interactive style, and you can do that very effectively on Zoom. I would just ask that if you do have some questions or comments, that you unmute yourself so we can all hear you and we can respond accordingly. I have a question for all of you. What is this notion of fiduciary? I mean, what does it mean and where does it come from? Fiduciary, you hear it all the time. You have a fiduciary duty. What does it mean? Somebody just said, no idea. Well, that's a candid response, I'm sure, and I appreciate that level of candor. And that's why we're here. Let's talk first, Lauren, if you could go to the next slide. Let's talk first about the sources of authority for this concept of fiduciary obligation or fiduciary duty. It's rooted in statutory law. Number one, if you're a condominium, you're governed by Uniform Condominium Act. If you are governed by the Uniform Plan Community Act, because you're a planned community or homeowners association, not a condominium, you're governed by Uniform Plan Community Act. As many of you well know, there's a third form of ownership, co-ops, governed by the Real Estate Cooperative Act. There are very, very few co-ops within the Commonwealth of Pennsylvania. There are a handful in the city of Philadelphia. I don't know if any of you are on a board of a co-op. If so, you can raise your hand or indicate in a chat. But we'll be covering principally provisions of the UCA and the UPCA. However, those provisions as they pertain to the infamous fiduciary duty are the same under the Cooperative Act as well. There's another statute. If you are formed as a nonprofit corporation, then you are also governed by the nonprofit corporation law in Pennsylvania. And there are a handful of really important provisions in that particular law which pertain directly to the affairs of community association boards as nonprofit corporations. And in particular, there's a very similar, substantially similar provision dealing with fiduciary duties under the nonprofit corporation law. So again, if you're a nonprofit corp and either a condominium or a planned community, you're not going to escape the statutory obligations that determine how you act as board members in your capacity as fiduciaries. So again, statutory authority, statutory duty clearly defined, and we'll go over that in a moment as to specifically what those provisions say. Next slide, please. Other sources of authority. That would be your governing documents. What comprise the governing documents for community associations? I'm sure all of you know, but just again, a brief summary. The principal leading document on the upper end of the hierarchy of documents governing community associations would be the Declaration of Covenants, Conditions, and Restrictions, sometimes referred to as the Declaration, sometimes CC&Rs, or you may call it whatever you want. I've heard people refer to it as the Bible, among other things. Okay, CC&Rs, they are recorded instruments, and they are at the apex or the top rung of the ladder in terms of governing your standards of care. Many, not all, but many declarations actually walk over the provisions in the statutory law dealing with fiduciary duties and mandate that as board members, you are governed and controlled by that standard of care. If it's not going to be in the declaration, then it may well be embodied within the four corners of the bylaws. That's the next rung of documents providing a source of authority for this concept of fiduciary duties. Rules and regulations, not likely going to define or articulate a standard of care such as the fiduciary duty. However, the documents will likely recite that in adopting or promulgating and enforcing rules and regulations in that context, you have to exercise as board members your fiduciary duty as otherwise described in the governing documents and or in the statutory provisions of the UCA and the UPCA. Any questions so far? Just kind of a brief overview from, as a former colleague used to say, 30,000 feet. Okay, next slide, please. All right, let's talk about the standard of care, what this whole concept means of fiduciary duty. To whom do you as board members owe a fiduciary duty, this standard of care that we'll talk about in a moment? Is it owed to the board? Is it owed to the members? Or do you owe a fiduciary standard of care to the entity, which is to say, your association? Show of hands. Most of you got it right. It's to the association, and it's very tricky. And it's one of the most critical pitfalls that board members face, as to remembering that when board members act, it's not action taken on behalf of or for the members. One might think, well, wait a minute. What's Sugarman talking about? The association is comprised of members. Of course, those are the folks that we have to take care of. Wrong. It is not the case. And there may well be, and oftentimes are, direct conflicts between what may be considered in the best interests of the members as individuals versus what may be considered to be in the best interest of the entity to whom you as board members owe your fiduciary obligation, which is to say, the association is the party that you need to be responsible for. Let's look at the actual statutory language. In addition to the acts making it clear that you stand in a fiduciary relation to the association, not to the members, it lays out the standard, again, walked over from corporate law into the UCA and the UPCA. I'll just read it real quick. There's some legalese here, but I think it's important to highlight the specific language. In the performance, I got to put on my reading glasses here. In the performance of their duties, the executive board shall perform their duties, including duties as members of a committee, which is important, of the board. Here is the critical language, and it's on the slide. In good faith, let's think about that for a moment. In good faith and in the best interest of the association. And so that's one, good faith; two, in the best interest of the association. And with such care, including reasonable inquiry, skill, and diligence, as a person of ordinary prudence would use under similar circumstances. Sounds like a lawyer must have written that, right? Now we can litigate over what all this means. And there are many cases that do, in fact, have as the source of the debate what this means. But let's break it down quickly, because I think it's really important for you to recognize, as you serve as board members, you've got to follow this standard of care in good faith. All right, let's think about what that means. Does that mean that you should act kind of in a knee-jerk reaction, in an emotional reaction? No, you've got to think about it. It has to be some real deliberation. And we'll talk in a moment about the next prong that really gets you and underscores the primary basis for this standard of care and how you can exercise it effectively. But let's talk the next line: best interests. Not in a reasonable interest, or not in the best interests of the association, emphasizing it's the duty owed to the association. And with reasonable inquiry, which would suggest you need to ask questions within some reason. Skill and diligence, as a person of ordinary prudence would use. Common sense? Absolutely. But what's the next prong? All right, there's your lead-in. So that's your overarching standard. But how do you really exercise reasonable inquiry? You just ask other members? You ask Lauren and her colleagues at CAMCO as professional managers, what should we do? The best way to discharge this standard and to act with all of these words underlined, in good faith, in the best interests of the association, and with reasonable inquiry, skill, and diligence, is to seek out the advice of third-party professionals, including professional property managers, lawyers, architects, engineers, competent contractors, folks that are in the know who can guide you, even if you conclude, well, I've been there, done that. I'm retired now, but when I was working, I served as an engineer on certain jobs. And yeah, this is a civil engineer's job, but I have a mechanical engineering background. That's good enough. No. You need to be able to rely upon competent and reliable and qualified third-party professionals in order to discharge your obligations. The next subsection, which is not specifically, I don't think, let me just check my slide. Actually, this would be a good time to turn it. It would be. Lauren, next slide, please. Okay. The use of third-party professionals is, once again, expressly stated in the body of each of these statutes. The language specifically talks about, in performing duties, that is to say, these fiduciary duties, a board member shall be entitled. This is good stuff. It tells you what to do. That's why I say, carry this section, 3303 as a condo, 5303 as a planned community. Carry it with you. It tells you what to do. You are entitled to rely in good faith on information, opinions, reports, statements, including financial statements and other financial data prepared by any of the following. And then it lays out essentially what we have here on the slide: reliable, qualified third parties. Get the report, get an opinion, because if you do, you now have the basis to say to your members, who may say, why did you do what you did? What agenda are you following? Is there a hidden agenda here? How many times have you heard those questions posed? Or perhaps even more importantly, let's look at the reviewing court, because you may be sued for the decisions you made or didn't make. The reviewing judge is going to say, why did you make that determination in that fashion? Okay. There was a unit owner who extended his or her deck 4 feet out into the open space area, submitted an application for the deck to be extended, but to the proper boundaries as permitted under the rules and regulations. But during construction, an additional 4 feet was tacked on, with the knowledge of the homeowner, who said, big deal, it's open space. I'll just grab some open space beyond where my deck is supposed to go. Do you then enforce the architectural guidelines and, again, in a knee-jerk reaction, file a lawsuit? Maybe you want to consider what's the impact of that encroachment. Maybe you can negotiate an agreement with the owner. Or maybe the encroachment is not just a strict violation of an architectural guideline, but maybe the problem is because the deck now crosses over and intrudes upon an important stormwater facility, a swale, through which a portion of the stormwater on your site is supposed to flow, but the deck now impedes that flow. That's a problem. You might not know that, you might suspect it, but isn't your case entirely different? If you then retain that engineer, not going to be costly. Yeah, if you're looking at plus or minus $1,000, maybe $1,500, from a qualified engineer to come out, take a look, and issue a report that says the deck's got to go. You already thought that because it was an encroachment beyond what should have been built, but now you have the goods, do you not? Because now it is a big deal. Now, when the judge asks, why are you here? Remembering, of course, that the courts don't really want to see these cases paraded before them anyway. So if you're going to go into court and try to enforce architectural guidelines through the exercise of your fiduciary duty, make sure you secure a reasoned opinion from a qualified third-party expert that says, or more importantly, answers the question, why are we here? Why are we pursuing the claim? And you have your Exhibit A. I'm holding up. Here's Exhibit A. Your Honor, this is why we're here. Because this is not just an encroachment of the 4 feet, but it seriously impairs the community's stormwater management system. And here's why. Totally different case. It's a winning case in all likelihood. And it demonstrates, just by way of just a brief example, of how, if you exercise your fiduciary duty in accordance with the dictates of the statute, you'll be able to be responsive to the question as to why did the board reach that determination or make that decision as it did? Because you followed your fiduciary standards, you got the opinion from a third-party professional upon whom you have every right to rely. Remember what I said from the language in the statute? Shall be entitled to rely in good faith. Totally different scenario in your decision-making process if you have what could even be a healthy debate amongst the board members, but unless you can root or plant your decisions in the turf created by the third-party professionals, your decisions are much more likely to be questioned, not just from the members, who will be the first line of attack, if you will, but questioned by opposing counsel who takes the case, and certainly by the reviewing judge, who again is going to ask that question. I guarantee you the judge is going to ask that question, why are you here? So you need to be able to be responsive effectively and sufficiently by obtaining reports, I can't say every time, but just about, even if it seems mundane or unnecessary or an unreasonable expense because, well, we all know this shouldn't have been done, or was a bad idea for the unit owner to have violated documents, or we don't need to make that fix now or have that inspection. We can wait. Can you? Did the homeowners at Surfside, could they wait? We'll talk about that in a couple of minutes. But even the timing of your decision-making as to when certain repairs should be effected in your community, whether structural or otherwise, all of those decisions should likewise be made based upon the advice of third parties. Some of you may have some good ideas and feel comfortable and competent to render a decision without any third-party advice, but why do that? Because if you fail to make your decision based upon the advice of third parties, you have not followed the direct dictates and mandates in the statute. So that means at the end of the day, and I don't mean to frighten you, but you're now exposed to potential liability because you didn't do what the state law says you should be doing. So my question is to board members, why not? All right, so it's going to cost a few dollars. But if we know we can now be insulated from liability and we can then utilize the report to effectively protect the interests of the entity that we are statutorily required to protect, that is to say, the association, why wouldn't you just go out and get that report? It's a good idea, a sound idea, and most significantly, and here's what you're all going to love, because I do, the same statute to which we've been referring and upon which you have a right to rely says that the executive board and its members shall have, that's the language I mentioned earlier, no liability if you follow those standards of care. This was a provision that our CAI's Legislative Action Committee had pushed for a good number of years ago, and that's a section that was amended in each of the statutes, providing for no liability. So not only then, just to summarize on this point, not only then do you have specific requirements and standards laid out, notwithstanding some of the legal language. If you break it down, it seems pretty clear what your standards of care are, and most importantly, your right to rely upon third-party professionals. Then you get the icing on the cake, which is if you do all of that, there shall be, quote, no liability. So again, it all kind of flows naturally into following those requirements, and then at the end of the day, being comfortable that having done so, there shall be no liability. It doesn't mean you won't be sued, or it doesn't mean you won't have some consternation or upset or the rotten apples thrown at you from upset or homeowners. Those are just part of the program. And that's why you're paid the big bucks as volunteer board members. But all kidding aside, if you do those things, you will have a shroud of protection. And that's extremely important if you do have to face either litigation or challenges to your decision-making process. It's much, much easier to defend and win if you have those reports from the third-party professions. All right, next slide, Lauren, please. Okay, a similar concept, but one that is not exactly the same, although it's oftentimes confused, is this concept of business judgment. Certainly, if you follow the fiduciary standards as we just discussed, there shall be no liability. But the business judgment rule, and this question is frequently asked by board members, what does it mean when you say exercise sound business judgment, and is there a rule? Well, there is, as the slide points out. It's a judicial rule. It's not a statutory requirement of the kind that we just discussed relative to fiduciary obligations. It is a rule of deference, which has been adopted for the most part in Pennsylvania. And I say for the most part because, as those of you who may have experienced court proceedings, you never know for sure how the court might come out on a particular issue, but there is sound decisional law in the Commonwealth of Pennsylvania and elsewhere that in the event the board makes its decisions within the scope of its authority, meaning that you had the right to control the common elements and the architectural controls, or you had a right to assess each unit. And of course, that's a statutory right and a right in your declarations. But as long as the decision of the board was made within the scope of the board's authority, and you made it in good faith, that word again, or those two words, and without any fraud or self-dealing, you acted for the association. You didn't act in a manner that benefited, the son-in-law's contracting company and why you awarded the contract to the landscape company because of a family relationship, or acted with some kind of fraudulent intent to defraud the association. That's rare, very rare, although it does happen. But if you can demonstrate, A, acted within the scope of your authority, and B, you made the decision in good faith without the fraud or self-dealing. Many of our courts, if not most, are actually duty-bound to uphold those decisions based upon the business judgment rule, including whether or not to enforce restrictive covenants. We had a matter just last week we were discussing about an owner who had a medical condition and was smoking marijuana. Now, of course, there are issues under the Fair Housing Act and discrimination based on disability. We won't get into those. That's another topic of discussion for a board program on another day. But evaluating whether or not to take action, whether it's with respect to those kinds of violations, there was a no smoking rule in effect for the community in that particular case, or whether it's enforcing the deck construction claim, or whether it's enforcing whether or not trash cans were brought in at the proper hour of the day after the trash was picked up. I mean, there's a whole host, as many of you, if not all of you know, rules and regulations that are adopted by the board on the heels of your authority under your declaration and the statute. But making determinations based on your fiduciary standard of care, and then coupled with this judicial rule of deference, if you follow these procedures, you'll be in really good shape when it comes to responding to the challenges. And I assure you, I always stick my finger up, this finger, and say, there is always going to be one unit owner within the community who's going to take issue. There may be many, many more than one, but there's certainly going to be at least one who's going to question your decision-making process. Adhere to these specific requirements and guidelines, and you'll be in good shape. Also, this notion, and I cannot overemphasize, a key element, because even if we talk about fiduciary duty and the business judgment rule, most of the time, the principal focus, even if not articulated by our reviewing courts, it's rooted in this notion of reasonableness. Have the boards acted reasonably? And again, that's kind of a wishy-washy concept. What does reasonable mean? Is it like beauty being in the eye of the beholder, or obscenity, as our Supreme Court said, not knowing what it is, but you know it when you see it? Well, reasonableness is kind of in that same camp, is it not? But again, it represents a cognitive process relying upon the advice of third parties. It's all part of the same notion. Now, that you shouldn't act in a knee-jerk fashion, that you shouldn't act in a manner that might be good for you and your neighbor, and it may not be good for the entity. Act reasonably on behalf of the community association. Next slide, please, Lauren. Any questions so far? Looks like somebody has a hand up, actually. Is that Karen? I'm sorry, Karen, I didn't see that before. You want to unmute yourself and ask the question? Is Karen with us? Okay. Let's move on. Avoidance of, we have another question? Okay. Statutory shield, we talked about avoiding liability. To me, that's one of the biggest or strongest underpinnings to this whole notion of fiduciary care, is to make sure that when you act in a manner that protects you from liability and enhances the interests of the association. If you can't conclude in your decision-making process that what you're doing is in the best interests of the association, then the decision-making process is flawed. Think about that. Is it in the best interests of the entity? If any of you have any particular war stories or questions regarding what that means in terms of your specific issues, now's the time, as we like to say in these programs, you get some free legal advice, although of course you get what you pay for. But nonetheless, I'm happy to respond to some specific instances to kind of put it in the context. I have a bunch of war stories I can share with you, but I always like to hear from attendees at these kinds of programs because it's an opportunity for you to voice any questions and discuss any particular issues that might be prevailing in your community. Let's talk for a moment about, I think there's one more slide here, Lauren. Yeah, why don't you flip it over to the next? I know we have a limited time frame here, and I do want to take some questions at the back end. Let's talk about reserves for a minute, because I know there are a lot of questions raised, and I frequently am asked by clients as well as from attendees at similar programs, what about reserves? What do we do as fiduciaries? Nobody likes to assess for reserves. I can't tell you how many times, especially with over 55 communities, where homeowners will say, well, wait a minute, I don't care what happens 20 years from now. I'm not likely to be here. Well, that may be the case, but does that mean, again, if you're a fiduciary, you have to act in the best interest of the association? Isn't it important to make sure that you're setting aside sufficient revenues so that when the useful life of a component, whether it's a roof or a roadway or stormwater management facilities or exterior siding, if you're charged with that responsibility, that there's enough money in the kitty? Well, we don't care, because 20 years from now, if they don't have enough money, they'll just special assess. Really? Would you want a special assessment now because of inadequate funding for reserves? Reserves are a big deal. And a well-run, successful community has sufficient reserves based upon an analysis performed by, here we go again, a third-party professional, a reserve specialist, engineer, or someone designated as a reserve specialist under the CAI designations. Get the reserve study. Many original builder developers or declarants fail to secure an adequate reserve and just throw some numbers into the budgetary hopper and hope for the best. Well, if you're transitioning from a declarant control board to a homeowner control board, for sure, you need to secure a report from a third-party reserve specialist. But it should be continued to be done. Some might say every 3 years. You could probably stretch that out to 5 years. Why? Again, so that you can look at your budget and make an informed determination based upon the advice of a third-party professional that this is what you should have in the kitty in order to address effectively future major repairs and replacements. That's the buzzword for reserves, future major repairs and replacements. Is that statutorily required? We talked about statutes. Is that a requirement under our state laws? Anybody know? Answer? No, it's actually not. It's actually a best practice for sure, just like you would set aside a reserves as a homeowner in a single family home that did not have a community association. Would be a good idea for your own personal budget to have a rainy day fund, right? Well, same idea walked over to a much, much larger scale, but it's not statutorily required. Is it required in the other source of authority we talked about at the outset, i.e. your governing documents? Yep. That's where you'll find them, either in your declaration or in your bylaws, invariably. And even if it doesn't exist there, it's still a real good idea to have sufficient reserves. If you have those reserves set aside, then again, you can withstand the likely challenge from the homeowner that says, wow, we just had a major hurricane. Think back to Hurricane Ida. How many of you had serious water intrusion problems as a result of that massive 500-year storm, right? Everybody did. Did you have enough money to fix things? Hopefully you did. Many communities did not. They didn't adequately reserve, or they had reserved, but this was an emergency, not anticipated. And certain financial resources had to be used. Many communities were able to either use directly reserve funds and kind of hasten the process in terms of the expiring useful life, or borrow from reserve funds. But if the money's there, it's a far superior approach than having to do what none of you really want to do, nor do I want to have to recommend that you do, which is impose that politically unsatisfactory result, which is special assessment. Nobody likes those. You certainly would have the authority most of the time, but not always. That's where you might want to have your lawyer, third-party professional, come in and say, could you use a special assessment tool to effectuate repairs caused by Hurricane Ida? Many documents, believe it or not, may not permit you to use a special assessment for that purpose. Many do, but not all. So again, before you act, you need to take a look at your governing documents, confer with your legal counselor, and determine whether or not you have, and I'm going to use that A word again, authority to do what you want to do. If you don't, then you may also want to work with your legal advisor to perhaps amend your documents so that in the future you will have that authority. And if it's not in your docs, perhaps your attorney would be able to advise you that it might be available to you as a remedy under the statutory law. But again, these kinds of analyses, they all kind of flow from the same critical element, which is to say, exercising your fiduciary duty to make sure that the financial affairs of your community are maintained effectively and properly, utilizing your lawyer, your reserve specialist, and other third parties to assist you in that process. Now, with respect to some of the more catastrophic events, we talked a minute about the recent hurricane, because I know many of you had to confront that. But the Surfside scenario, the Lake Champlain Towers, is a really good example, as horrific as it was and as sad and catastrophic as it was. It does underline for community board members many of these same concepts we just talked about. Making inquiry. How are your community's financial affairs situated with regard to various boxes that have to be checked off? Do you perform periodic inspections of your common elements? Did you bring in your engineers, not just for reserve study purposes, but for periodic inspection? You know, how is our subsurface garage looking? What about our roofs? We thought we had a 20-year roof useful life, but you know what? They're not looking all that well. Maybe they're deteriorating prematurely, or maybe because of climatic conditions or the location of certain buildings, they're getting more sun or more wind-driven rain. But in any event, perhaps we need to up the timing to effectuate repairs. These are all the kinds of questions that you need to ask and should have been asked incident to the Surfside catastrophe. You probably know that there was a settlement in that case of in excess of $1.2 billion, $1.2 billion, contributed by various parties, including the association. You don't want to have to face that kind of challenge. I'm not saying you'd see anything close to that type of loss, but it just puts it in perspective that the best way to prevent your having to deal with anything close to that is to satisfy these fiduciary obligations in the manner we've just been discussing. We do have several questions here. Let me see if I can. Let me scroll up. Sorry, I have to read here.
It's okay, Stephen. I can do that for you.
You want to do that for me?
Yeah, no problem. So
Okay.
Tammy asks, what happens if you have an excess operating surplus as an HOA and nonprofit, and how does one determine if it's excessive?
That's the second. Thank you, Lauren. The second question is actually, in many ways, the most important, because what does that mean to be excess? If your income exceeds your expenses, that would normally, under the normal nomenclature, constitute excess or a surplus. And the Acts actually provide statutorily that you're supposed to give back the surplus. Does that happen in, as we say, day-to-day real management of community associations? No, it doesn't typically, because guess what? Most associations could always use the funds. So the notion of what is excessive drives the answer to the question about what happens, because you may determine, and your reserve specialist may have said, you know, you have inadequate reserves. So maybe the excess or the surplus gets rolled over into the reserve account. Or maybe you use those funds to do a project that you had budgeted for, but hadn't budgeted enough. So rather than special assessing or amending your budget for that next year, roll over those dollars into the current year's budget and use those funds to perform the maintenance, repair, or replacement obligations that you are required to undertake. But again, I want to point out that technically there are provisions which would authorize, if not require, a return, but only if those are truly considered to be a surplus. And that determination is not necessarily made solely upon whether the income exceeds expenses.
Valerie has asked, are we obligated to provide a generator backup at significant expense to protect ill or disabled occupants?
I'm sorry, Lauren, could you repeat that, please?
Sure.
There you go, I have it here.
Are we obligated to provide a generator backup at significant expense to protect ill or disabled occupants?
Well, I'm going to have to say it depends. I'll give you that classic lawyer's answer, and it really does depend on what your documents provide. This question would suggest that perhaps there's some obligation to provide a generator backup to begin with. More often than not, associations are not in the business of providing backup services, electric or otherwise, utility backup to homeowners. And that individual homeowners are the party who would normally endeavor to protect themselves, whether they're ill or disabled or in need of particular electric or utility backup. So it really depends upon what the documents provide. If an owner is truly disabled within the meaning of that term under the Fair Housing Act and requires a reasonable accommodation or a modification to his or her or their unit in order to protect themselves in light of that disability, and if the generator was obtained by the association, then arguably the association would have an obligation to maintain the generator. But typically associations are not required, absent some agreement to the contrary, to protect individual homeowners. That's an individual unit owner obligation. So, yeah, but again, you'd have to look at the docs and see what they provide and see whether there's any affirmative obligation for the preservation of health and safety to individual homeowners. Not likely, but possible.
And then our final question that came in through the chat is from Julie, and she asks, what expertise would you be able to tell us about associations that borrow from the reserve funds to pay for overages under operating expenses and subsequently don't have enough in the reserves to pay for upcoming capital projects?
That's a good question, Julie, and one that unfortunately is faced by many, many associations. But isn't the reason that that question surfaces because the associations have not adequately budgeted in the first place? Which is why I go back to what we've been talking about this entire hour, which is get your financial affairs in order based upon the advice of your auditor, your reserve specialist, your professional manager, and any other parties who can chime in as to what kind of dollars need to be set aside, not just in your operating account, but in your reserve account. If you do not have sufficient revenues in your operating account, the general proposition, and there's very little decisional law on this, and frankly, it's not usually found within the governing documents either, as to whether or not you would be legally permitted or have the authority to borrow from reserves. I can tell you, however, that as a general practical matter, many associations, unless again there's something in the documents expressly stating to the contrary, many associations would generally have the authority to borrow from reserves on an as-needed basis. Again, I frown upon that because it's not what's supposed to happen. But in an emergency where additional funds are needed and you have sufficient funds in the reserves, an association board could, for a limited time period, borrow those funds, as I see it, with the proviso, and a very important proviso, that the association's board make arrangements for the repayment of those reserves back into the reserve account. So typically what would happen would be the next year, let's say you borrowed in 2022, in your 2023 budget, the board should take into account that shortfall created in the reserves because of the transfer of funds and make arrangements under the 2023 budget for the payback of those sums that were transferred in 2022 from the reserve account into the operating account. So yes, it can be done, but going back to your second prong of your question, if you don't have enough in the reserve to pay for upcoming capital projects, again, that would highlight the fact that you didn't have enough to begin with, or if you didn't have enough, if you didn't have enough in your operating account and then borrowed and you didn't make arrangements for a payback, that would engender or trigger this phenomenon. It shouldn't happen if the board is exercising properly their fiduciary obligations. Want to turn to the next slide then, Lauren, if there are no more questions in the chat. And let me check out of this. There we go. Okay, so quick summary. And then if time is permitted, I'll check the hour. Yep, we have a few minutes for additional questions. Quick summary, what I call the Best Practices Act. And a lot of this really is a function of what's the best practices. Yes, statutory authority. Yes, governing documents provide authority, but there are some general principles and guidelines which, if followed consistently, will inure to the benefit not only of all of you as board members, but certainly to the party for whom you're responsible, which is to say, the association. Number one, act promptly. Don't delay. Don't kick it down the road. Well, we'll worry about that later. Oh, you know what? The Phillies game is on tonight. Let's break up the board meeting now and catch the game. Okay, maybe one time or two times, but if you keep on avoiding your responsibility, it's going to come back to bite you, for sure. I see it all the time. And act consistently, meaning that if there's a question that surfaces regarding your legal authority, get the advice of your lawyer. If you have a question regarding the condition of your common elements or condition of other components for which you bear responsibility. For example, in the context of a planned community, the unit may consist of the exterior siding and the roofing material, but it may also be your responsibility to maintain, repair, and replace, even though the association doesn't own those components. Well, if you're not sure what it is that you should be maintaining, be consistent, get the third-party opinion from your legal advisor, and you make your decision on that basis. So act promptly and consistently, act upon the advice of your third-party professionals. And here's the other thing. Don't shy away from the facts. Sometimes the facts are ugly. Yes, you've been underfunded for the past 5 years. Yes, the declarant didn't adequately fund from day one during the period of declarant control. We didn't pursue that back in the transition, and now we've got to face the fact that we're really underfunded in our reserve account. When you perform your investigations, your roofing, your siding, your walkways, your stormwater management system, your roadways, you didn't do the test bores during transition to see whether or not the roads were properly installed. Well, guess what? If that's the case and it was missed, it doesn't mean you have to turn around and sue the former board for failing to have investigated, but face the current facts and figure out, with the advice of your third-party professionals, what you should do about it. Get your report, get your evaluation, discuss it amongst the board members, and come to a reasoned and reasonable decision based upon the facts. Don't try to hide the facts and leave them for another day. Act with due diligence and act reasonably, as I point out in the last prong of the Best Practices Act. I have never seen a situation where a board that acted reasonably, even if challenged, came out on the losing side of that argument. But you still have to develop your position based upon those standards of care. If you do, you're going to be, as I said earlier in this discussion, in really good shape. If you don't, then you're likely talking to either your insurance agent when the lawsuit is filed, or your lawyer who's defending the association based upon the failure of the board to have followed the express written standards laid out in these governing documents and in your statutory law. With that, let me see if there's another question. I think one just came in. There's a question pertaining to the statutory reference. Yes, I did that at the outset. I don't recall the specific site in New Jersey. I'm not a New Jersey practitioner, but certainly in Pennsylvania, if you are on the board of a condominium association, then you want to look at section 3303 of the Uniform Condominium Act. If you're on the board of a planned community, sometimes referred to as an HOA, then it's section 5303 of the Uniform Planned Community Act. Those statutory provisions lay out these standards of care with regard to fiduciaries in the Commonwealth of Pennsylvania. If you don't have those sections by your side now, I would urge you to go to our firm's website, www.sugarlaw.com, and you'll see under the resource tab, we have all of those statutes that are available just from an easy link. Click on the link, go to 5303 for the UPCA and 3303 to the UCA. Print them out, put them in your board packet, leave them by your nightstand. Put them in every room of the house. I'm exaggerating, but you know what I mean. You want to be able to fully appreciate and comprehend those concepts anytime you're sitting on a board for a community association. There's another question from Tammy. Is it the board's fiduciary duty to pursue collection of past due fees to the point of executing a judgment against the homeowner? Broadly phrased question, but again, it's a helpful question, Tammy, because it certainly demonstrates the very stuff that we've been discussing this evening. A decision as to whether or not to pursue collection of past dues is a perfect decision-making process falling within this concept of fiduciary standards. Make your investigation, right? Act in the best interest of the community. I think we can say collecting assessments is in the best interest. Everybody's supposed to pay. That's the rule. You know that going in, and it's a deed covenant. Somebody doesn't pay. Why? Why not ask why? Isn't that going to inform you as a board as to whether or not, to respond to Tammy's question, you might want to pursue a judgment and then maybe execute on the judgment? Just because somebody is delinquent doesn't mean you have to go hire your lawyer and file a lawsuit. Use your standard of care, use your standard of reasonableness, ascertain what the problem is. Maybe the person was laid off from his or her job. Maybe the person's ill and is in a rough bind. So maybe you work with that unit owner and say, you know what, you can defer for the next month or two, but you need to make that up promptly thereafter. Enter into an installment agreement. It was $500 a month, pay half that for the next 3 months and then make it up the following 3 months. Something. You can work that out. That's acting reasonably and in the best interest of the community. And guess what? You avoid having to bring in an attorney and incur the costs and fees incident to collecting on the unpaid assessment. On the other hand, if the unit owner's response is, I ain't paying because I don't like the board, or I'm not paying, these are real cases, I'm not paying because the association failed to eradicate the beehive, remove the beehive from the tree next to my front door, or because I didn't like the snow removal job last winter and I was delayed in getting to work 15 minutes. I had to wait for the snowplow guy to clear my car out. I'm not paying. At least in Pennsylvania, those excuses no longer fly. There's sound decisional law that says, no, you still have to pay. If you don't like what the board's doing or not doing, you can exercise your remedies by pursuing your own claim, but you still have to pay. If, on the other hand, if the question was further, Tammy's inquiring that what I've just said had been done, but the owners failed to meet a new agreement, which terminated upon non-payment, has been going on for 6 years. Well, those are additional facts. Again, every decision is driven by the facts, which is why you need to make your investigations and exercise your due diligence. So that changes the scenario, does it not? Now you have an owner who is not only delinquent, but then entered into an agreement to pay. Great. I'm a big fan and advocate of that. But the owner breached the agreement that was entered into with the association and didn't pay under the agreement. According to Tammy now, this has been, quote, going on for 6 years. That's a long time. So what happens? If the owner's not paying, every other homeowner within the community has to make up the shortfall, right? Is that fair? Is that reasonable? No. No reviewing court's going to say, yeah, no problem. You know, Mr. Jones isn't paying. Yeah, let Mr. Jones slide for a few years. Everybody else could pick up the tab. Who cares? No, that's not likely to be the reviewing court's position. So it sounds as though in this scenario that with the extended period of time following an agreement, which unfortunately was not adhered to, the association, absent any other facts that we may not be aware of from this scenario, would certainly have the right to pursue whatever enforcement remedies might be available, either under the agreement, which was violated, or under our state law, which, as many of you I'm sure well know, include the whole gamut of enforcement rights. You could get a judgment against the owner. Maybe that was part of the original agreement, that a judgment was entered. You could execute. You can execute on a judgment by going after bank accounts, automobiles that may be owned by the individual, personal property. But if we're talking about a 6-year period, and depending upon how much is owed, executing on those kinds of personal property assets may not be sufficient. There's a really good remedy available to an association, either under the Condominium Act or under the Planned Community Act, again, which should be exercised with caution because it's an extreme remedy. But associations in Pennsylvania do have the right to do what mortgage companies and lenders have the right to do, which is to foreclose on the unit. So in this scenario, and again, depending upon how much is owed and what the terms of the agreement may have been, but if there's nothing to the contrary in the agreement, then an association in this scenario may well have the ability to simply proceed in a lien foreclosure action, where you would pursue your remedy to collect your unpaid assessments through a sheriff's sale of the unit itself, not personal property, not bank accounts or other personal assets, but the real estate would be subject to execution, either under a pre-existing judgment, which the association may have obtained, because you can walk that judgment over into a foreclosure claim, or, as many of you probably well know, statutes provide for a priority lien for associations in Pennsylvania. You can just proceed with your lien foreclosure because an unpaid assessment constitutes a statutory lien against the unit. So again, like a mortgage company, you could foreclose, sell the unit. The purchaser then kicks in proceeds to the sheriff, and you hopefully would be the recipient of those purchase proceeds. Tammy, did that answer your question? And if not, feel free to continue with another message.
No, it's more that I feel bad. You know, it's a divorce situation, but at this point, it's not fair to the rest of us that I mean, we've had 3 agreements in the last 2 years, and they just have, you know, every once in a while they'll throw a little bit of money, and they asked me if I wanted to exercise the judgment against her bank account today, and so.
Okay. Well, I mean, that would be a remedy if it's available. If the agreement did not provide any restrictions and you have a judgment, typically an association would have the right to enforce its judgment by attaching or executing against a bank account. But again, as I mentioned earlier, you don't want to go through a wasteful exercise. If there's $100 in the bank account and there's $50,000 that's owed, you may want to look at another remedy.
Thank you.
You bet.